First of all, thank you so much to Reem and all the other organizers for the invitation. Very happy to be here. I also want to join everyone in acknowledging today, National Day for Reconciliation, hopefully toward justice for the first peoples of this country and also North America. Now that I'm in the US, should be a holiday. I'm Nigerian, we have a holiday for everything. So Canada needs to learn from Nigerians, all right? And it's usually 2 days. What good a holiday if it's not 2 days? You feast and then you recover from the feast. It's actually true, it's not just a joke. But I'm serious. It's sad that it's not, and hopefully progress will be made in that direction. I acknowledge our presence on indigenous lands, my presence within Toronto, where my family still is, and in DC as well, for the North American indigenous peoples. And here, of course, in Windsor. Thanks to Alex for sort of showing us the lay of the land in terms so wonderfully of that nexus between security and human rights. We discussed and we thought he should go first because mine is a more particular, specific instantiation of or discussion of that instantiation. And I'm going to talk about refugee law and what I call security relativism, national self-image. So a lot of connections to both what Alex has said this afternoon and to a lot of the conversation we've been having since yesterday, right? And I'm going to do that. I can't talk about. I did a study of about 5 different areas in refugee law. So I'm sure we'll be here till tomorrow morning if I talked about all 5. So I'm going to simply talk about deportations to torture, again, connecting with what Alex has discussed and some of the conversations earlier. So basically, my discussion is on how human rights were largely put aside by not just the US, but by the Canadians post 9/11 in refugee law specifically, but even more specifically in this case, in the area of deportations to torture, but also that this was not a post 9/11 phenomenon. So that there's a very deep continuity, much more continuity than discontinuity from before 9/11. In other words, the 9/11 accelerated an already ongoing process. And in fact, I claim in the book that I'm speaking to that 1996, the year following the first World Trade Center bombings, was actually in this particular area, at the very least, as consequential as 9/11, right? In putting in place this regime that dehumanizes and mistreats refugees in North America. I won't get into all of it. Like I said, I don't have too much time. I'm giving you the 20-minute or less version. So the dichotomy between rights and security that Alex talked about has for a very long time expressed itself prominently in Canadian refugee law, as well as US refugee law. The 9/11 attacks highlighted this, of course, around the world. Of course, although the debate over how sort of new or fundamental the heightened security vigil that followed those attacks have raged since then for a very long time. How sort of deep or fundamental the changes that occurred. There were changes, of course, were or were not that it hasn't abated, right? Till this day, it's not completely abated. The conventional wisdom, at least at the time, was that there was rupture, right? I disagree with that. Many, of course, Remis here have sort of disagreed with that. It's not just me, but what I set out to do was to show that in the detail, in a granular way, in booklet format, in refugee law, and in specific 5 case studies. So there are two sort of levels or dimensions of the analysis. The first is pre and post 9/11, the changes wrought were not nearly as fundamental as you might think at first glance. The second was that the difference between the response of the US and Canada is not the gap between the two is not nearly, again, as vast as you might think at first glance when you look closely at the evidence that I looked at least in this area of refugee law. And I'm going to use deportations to torture to illustrate that. And then what does that tell us or not about security relativism, how deep it is, its circulation, embraced by both Canada and the US? And what does that also tell us about Canada's and the US's national self-image? Of course, we know what sort of the dominant national self-image is, not the image that dispossessed and mistreated First Peoples and minorities tend to have. So I'm not arguing, of course, that there were no changes whatsoever. It's about calibrating those changes, how significant were there, and what does that then tell us about this issue, this concept of security relativism and national self-image. Okay, so like I said, I'm going to use the much narrower area of deportations to torture. At the outset, I want to make clear that what I found in terms of deportations to torture is that Canada's law and practice in the area of these deportations to torture was either similar, very similar, or actually worse in a couple of cases than that of the US in at least 10 or 15 key indicative areas. All right, so 10 or 15. Canada's law and practice tended to be a bit better in 5 respects. Okay, so that should frame a lot of what I'm going to say. So just to have that. That's why I wanted to present that at the outset. Now, in terms of the similarity, I don't have time, so I'm going to sort of breeze through them. So very similar in the frontal attacks on the absoluteness that Alex talks about, of the prohibition of the bar against deportation to torture. A lot of people think that started to happen post 9/11. No, it started to happen way before 9/11 in both countries. People forget that both the federal court and the Court of Appeal in CRS would have sent him back to torture a long time before that case reached the Supreme Court. In the US, there were several, I don't even, shameless plug for my book, go buy the book, you see all the examples, okay? Anyway, that I offer. I mean, there was probably eight examples just on that, okay? So it's not something that emerged, post 9/11 or because of 9/11. Of course, the same kind of animus that was present in 9/11 was present before, but it wasn't merely. Definitional loopholes. So both pre and post 9/11, definitional loopholes with regard to who's a public, whether or not the person who practiced the torturer had to be a public official, right, was used to dodge the prohibition in both countries. The second was the definition of acquiescent to torture, and the issue, which was similar in both countries, was whether the test was mere awareness of the torture happening without taking steps to prevent it, whether it suffices as acquiescence, right? In the US and Canada, it was the position was that mere awareness of torture by a public official does not suffice as acquiescence. Them just being merely aware, right? You have to show something else. Now, those differ in those two countries, but the fact is that just merely showing that they were aware of it does not suffice to meet the definition. Renditions, we've been told about that, so I wouldn't waste time. Canada was complicit in many renditions to torture, deportations to so-called failed states, similar positions. I'm breezing through because of time. The dominant gatekeeping culture, I'm sure a lot of people here who have immigrant backgrounds will understand that, similar actually in both countries, both before and after. That's the gatekeeping culture of the immigration bureaucracy. Interdictions. In some ways, Canada is actually more efficient at interdictions at Frankfurt Airport and all those places than the US, but they were similar. Canada is actually, the position in Canada was actually worse, remained worse in terms of just the way, at the level of just text, the absoluteness of the bar or prohibition of torture was couched, right? So whether you look at the legislation or you look at sort of the controlling legal authorities, the cases, you see that at least at the level of text or practice, the US absolute bar was stated in a little more forceful way than post-Suresh, like if you read the decision in the Supreme Court in Suresh. Excuse me. Now, yeah. So the Suresh loophole, my point is that Suresh loophole is a little wider. Now, Canada is better, admittedly, in about 5 of those indicators. Mental torture is defined less narrowly in Canada than in the US. The standard of proof in Canada is substantial grounds for believing that torture occurred. In the US, you have to show that it's more likely than not, which is turns out to be a much more difficult thing to show. The scale of the deportations in the absolute terms to torture was likely higher. It's difficult to know how many of those rounded up and deported were actually tortured when they were, but the scale was likely much higher in the US. However, if you control for the number of especially Arabs and Muslims in the US at the time versus Canada, again, the gap narrows quite considerably. Expedited removals, Canada doesn't practice it, at least in theory, on paper. Diplomatic assurances, Canada is much more suspicious than the US about receiving diplomatic assurances from certain regimes that they will not torture the person upon their being deported. The US accepts them pretty much. Doesn't matter all that much the reputation of the country. Now, in terms of the overall Canada-US gap, and in terms of their the reactions of their refugee law regimes, post 9/11 and even before, there is a relatively small gap, much smaller than you would have first imagined. Also, the pre and post 9/11 gap was not as major as one would have imagined. Well, I also have to underline this. I have to do this every time I present this. My point, overall point, is not that there were not any changes or that the changes were not material. My point is that things were already so bad before 9/11 that there was actually relatively little room left, right? It's almost like if you fill up this room up to this point, there wasn't that much room to change because things were already quite bad in both countries for refugees. That's actually my overarching point in this regard. Now, very quickly, how much time do I have? Hold on. Okay. Okay, I'll do the 6-minute version, I guess. Maybe 8 minutes. In terms of security relativism, just to give you an idea, what do I mean by that, and what does all this have to do with that? Now, it's a bit of a riff of cultural relativism, right? So human rights are culturally relative to the extent that they arise from, or are determined by, or dependent in some sense on culture, right? So for me, this expression, security relativism, is grounded in the same kind of logic. And so the human rights, including those of refugees, would be relative, security relative to the extent that they are held to be dependent or arise from or determined by security. Of course, relativism, as Ben Bakshi has taught us, is a coat of many colors, right? There are many relativisms. And this is the same for security relativism. There's strong security relativism, for example, that, Falad Deshawiz and people like that would say human rights just suspended, torture them to save the world and all that. But there's also weak security relativism that says, which is sort of, to some extent, reflected already, as Alex told us, even in the scheme already of international human rights. Now, so my point, again, just to rush it through, is that in the book, I illustrate both weak and strong relativism and how that sort of was deployed by both countries very similar before and after 9/11, right? So, for example, in deportations to torture, the CRS case, once you're talking about an absolute ban, you say, well, sometimes we can send them, they're so bad that we can actually deport them to torture. That's a kind of strong relativism that was employed by the Supreme Court of Canada. Excuse me, and it's similar in the US. Now, in terms of national self-image, now I don't think I need to say much about this actually. In both countries, the dominant, perhaps I should, let me talk very briefly about what I mean by national self-image. Of course, we know that nation is fabricated, nation is imagined, right? That goes without saying, but it is nevertheless real. It nevertheless persists, right? In the imaginary, right? So it is a thing in a sense, as John Morse tells us, the specter of nation lingers, right? So, so if we understand that, then national self-image itself, again, is imagined, it's real. I also make the distinction between dominant national self-image and alternative national self-images around humanitarianism, around human rights, where, human rights state, we respect human rights, we're a humanitarian country, there's rule of law here, diversity, and so on, and inclusion. So you can have, dominant images and alternative images that are held by those who are not who have been dispossessed or oppressed by the state. Now, my point is that the actual data places troubles quite deeply the dominant national image of what the US as the shining city on the hill. We all know that Canadians love to almost revel about that. But also, more importantly for us, the fact that the country attacked, the Canadian response was so similar, so close to the country that was actually attacked, should trouble Canadians and should disturb, quite fundamentally, our national self-image as a human rights state. I'll leave it at that. I sort of, didn't discuss a lot, but I guess I've given you the gist of what I wanted to say. Thank you so much.